That's kind of interesting. This actually highlights the value of estate planning.
That's fine. I'll keep the 50 and I'll never have a relationship with y'all again. Wow. For $50,000.
I'm not going to say 100%, but I'm going to say 99.99% of the time. There's no sale that you're going to do privately with one of these investors that is going to be better in its outcome, financially and otherwise.
I would make money to tell you to do it, and I'm telling you, do not do this. You are going to lose money on this.
I would say as an attorney, real estate broker, you have to have a little bedside manner.
Any concern I had that AI was going to decrease business to us was gone because they got it so incredibly wrong, because we know that her brother is going to sue her. That is his stated goal, and the parents are refusing to name a professional. Money changes things.
It does. It does. It frequently does. I remember from the test, the real estate license test, and I thought, that will never matter. And all of a sudden this thing comes up, like, oh, I remember that. Yeah. That's an issue. That actually does exist in the real world.
We'll say, oh, this is a law school exam. Listen to this. Okay.
Hey, I wish you all the best. God bless you. If it doesn't work out, I'm always here for you. Welcome to the Texas Probate Real Estate Podcast, the show where we help executors, administrators, and families navigate the world of probate. Every show we bring to you wonderful guests that are experienced in the probate world, attorneys and other professionals that can help you through this process. Today, I have a very special guest. She's actually a very, very experienced attorney, and I'm really happy that we could have her on the show today. Her name is Pamela Hailey-Petty. She's the managing attorney at the Hailey-Petty Law Firm with offices in Austin and San Antonio. Since 2014, Pamela has helped numerous Texans organize their futures through her knowledge and expertise in estate planning, but she also regularly provides legal counsel to clients navigating the probate process. Pamela, I want to welcome you to the program.
Great. Thank you, Jeremy. Excited to be here.
Yeah, this is awesome. I've really been looking forward to having you on here. And Pamela, I want to, before we get into all of the interesting things that you're going to share with us today, I really want to just go into you as a person. I think I was doing some research on you online. I was kind of stalking you online and kind of saying, like, what can I learn about Pamela? And you just have such an interesting background. Pamela, can you do me a favor and just walk me through a little bit about, how you got into law, that story, maybe a little bit of your background. Tell us a little bit about your firm, kind of what you guys are doing over there, and then we'll get into what we're going to talk about today.
Sure, yeah. So I originally became interested in the law when I studied business law in undergrad. I just found it fascinating. Fast forward 5 years, did end up going to law school. And then I remember sitting in my wills, estates, and trust class, and I come from a ranching family, so lots of ranch land on both sides, my mom and my dad, and calling my dad after and saying, hey, was this ever handled? Did you do this? And him saying, wait, what do you mean? And, fast forward 16 years, it is still in litigation now.
Really?
And
Wow.
so that's what got me interested in estate planning and probate. And we hear this from a lot of clients. Well, it just shouldn't be this, this much, this, court involvement, that sort of thing. And so we really like, you may have seen this when you researched me, the educational approach and making sure clients understand what is going to happen. And, that's first and foremost for me, because I think, had my family understood that, maybe it wouldn't have turned out the way it did, So good planning up front can avoid a lot of issues later, is kind of the summary. But that's what kind of got me interested. And on the family side, I've seen all kinds of things. And if people don't think it can happen to them, they're kidding themselves.
Absolutely. Absolutely. That's so interesting. So it's really personal for you in some respects. It comes from a personal experience. And it's very interesting. That really means something, because that means you have it's not just theoretical. It's not just some sort of book knowledge. It's something that has touched your family.
Oh, for sure. Still does. Yeah.
Wow. Wow.
Yeah.
Wow. That's amazing. That's amazing. Tell us a little bit about your firm. You're in Austin and San Antonio. What are you guys doing? What are you guys doing in your law firm?
Yeah. Probably about half of our practices estate planning. You
Mhm.
know, a lot of clients that come to us, they're interested in trust planning. And a lot of times it is appropriate or a good idea. Sometimes it's not. So, but the majority probably do trust planning in addition to kind of basic estate planning. We do probate and guardianships as well as Medicaid pre planning. Sometimes that is fairly simple Medicaid pre planning, and sometimes it's more involved with the Medicaid asset protection trusts and whatnot. But again, just understanding, okay, this is how things would play out. So, really right now, we're really working on, I think we have a good base now, but really working on more resources for clients so that, they have a good understanding, maybe even before they get to us, kind of how things work. So, both on the estate planning and the probate and Medicaid side. So really trying to, educate. So we're doing a lot of webinars and, a lot of written resources for clients.
Pamela, I really like that. That's something that I have started to do in my real estate practice. So, when I started as a real estate agent, a little baby agent, and the ink was still dripping off the Trek license. Okay,
Yeah.
it was really about just trying to slam deals, just looking for clients all over the place. This August I'll be in real estate 9 years. When you're more established now, it's like okay. It's more about attracting the business to you. And so that's what I'm doing. That's actually, I'm so glad you said that, Pamela, that it shows like I'm really aligned with kind of your business philosophy because I,
Hmm.
I like to do a lot of education as well. And that's why we're doing this podcast. My hope with this podcast is that other executors, administrators, personal representatives, people who are not yet, like they're just starting the journey, that's going to give them an entry point to at least get some information and knowledge from people that know what they're talking about. That's why I like to have attorneys come on here because I'm not an attorney. I don't pretend to be one, but I can always get attorneys on here to talk about what they know best. And of course, I'm a real estate expert. I can talk about the real estate part, but the
Hmm.
legal part is very interesting with probate real estate, the namesake of our show here, Texas Probate
Yeah.
Real Estate, because with real estate, with probate real estate sales, we intersect with the law in a way that is a little bit more intense than other kinds of sales. And
Yeah.
so
Absolutely.
so education is really important. And that's awesome. That's awesome. And just one quick thing, Pamela, is what I find is that, leading with education is so great for business as well, because, it allows the potential client or customer to learn something, but also experience you. They can experience you before they meet you. And finally, when
Hmm.
they do reach out, it's almost like they know you, which is
Yeah.
wonderful. And the ones that we don't want to work with and don't want to work with us, they just weed themselves out. So it
Yep.
works out.
Yep.
So that's great. Well, what I'd like to do now, Pamela, is I'd like to just kind of get into our subject matter now.
Hmm.
And there's a few things we're going to cover in this show, in this episode. Let's go ahead and start with kind of the nitty gritty. Let's just say we have a wonderful human being and mom has passed away and it's devastating. And there's a house that they've got. Maybe they're out of state. That's very typical, right? They're out of
Hmm.
state. There's a little bit of money, money in the bank account. Okay. The mortgage is auto paying from the bank account. Okay.
Mm.
They maybe have a month or two going on, of reserves there. Mom has some credit card bills. Okay. They had the funeral, but now the reality is hitting. It's like, okay, the bills are coming in. Let's just say they were divorced. Dad's not in the picture, so it's just her. And bills are coming in. Now it's like, okay, now I have to take care of the business, right? I was putting it off. I'm getting the mail. I'm getting these notices. What do I do?
Mm. Yeah. And that's, so many things.
Take your time. We have all the time in the world.
That's very common scenario. So I'll kind of go off on, a few things where it could vary, where we get different answers from clients. First, I'm reminded, and that's often what we hear, but occasionally we'll have somebody come in within days of somebody passing. And it's because either other heirs or other beneficiaries in the will, depending on whether there's a will or not, are, sending letters already to them that, you have to take action or I will sue you kind of thing.
Really? Okay, now I haven't heard
Hmm.
that before. I have not heard that
Yeah.
before.
It's not
Can you
very
tell me a little bit?
often.
Can you tell me a little bit more about that? That's interesting. I haven't had anyone talk to me about that.
Yeah, this particular, and I know there are others, but this particular client, I think it was 2017, 2018. So it doesn't happen often, but funeral hadn't even happened yet. I think it was 2 or 3 days after her grandmother had died. And I mean, this is all public record. So she was the named executor, and her family members had hired an attorney. And, it was one of these, quote unquote, bulldog attorneys that, sent her a letter. So she comes to my office. Grandmother had just passed away 2 to 3 days prior, and, showed me this letter from her family member's attorney. You have to probate the will. And forcing it very quickly. And she was just distraught, obviously. I don't think she had a great relationship from memory with him, but it wasn't terrible. And then it got terrible. But, she did not want to be dealing with that, obviously, at that particular moment.
Mhm,
But we had to, so, we didn't breakneck speed do it, but she hired to, get it
mhm.
started and to have me respond. And it was something that needed to be done anyway. But, often we see people that are surprised by their family's actions in that moment. That's a more egregious example. And that's
Pamela,
not
can I
the
ask you a
only.
question? Can I
Mhm.
ask you a question about that, Pamela? Does it matter if there's a lot of money at play? Can it be a little money or a lot? Like, I should say the asset value. Like, does it matter or does it not matter?
Something that I very often say to clients is people always expect more.
Right.
So it kind of doesn't matter what it is. It could be $100,000 or even $50,000, and it could be 5 million. And people, if that's who they're going to be, the value doesn't matter. But they always think there will be more money. That's a pretty consistent thing. But no, it doesn't matter. Yeah. I mean,
Okay.
there's another, and I don't think they hired to do anything because there was so little money, but I can think of an example for that. I remember a potential client calling, and essentially one of the family members had run off with $50,000 and said, that's fine. I'll keep the 50 and I'll never have a relationship with y'all again. Wow. For $50,000.
Wow. Wow.
That's not okay.
Pamela, it's interesting. As someone who deals in real estate, I often, when I am approaching people and we're contemplating doing business together and okay, we start off, we sign all the documents, we get the ball rolling. There's a lot of money involved typically. It's their largest asset typically. And it really can bring out because there's so much pressure and stress involved, it brings out the worst in people, even though they
Hmm.
don't intend it. And not all the time, but it can bring out the worst in people. And it's amazing how when you add money and other kinds of pressure, especially money, it's amazing what comes out, what comes out of the woodwork.
Yeah.
It's a very powerful trigger for a lot of people.
Yeah. And even very little. I
Yeah,
mean, sure,
yeah,
50,000 would be great, but I
yeah.
mean,
So going back to our scenario, so they've come to your office, and where do we go from there? What are you telling them?
so, in this scenario, okay, we have a house, bank account, bills are coming in. And something that I talk about on the estate planning side is when we talk about how to plan, what do we want to put in place for the executor? Those bills, they don't stop when you pass away. Often they increase. And at the same time, you might have a cutoff to any assets, pretty common, or the assets, go to named beneficiaries. And so, you might be left with only a house. And then the question is, how do you pay for it? So in this scenario where, we have the house, the bank account, we sit down and we kind of do a dive on what are the assets? Have any been paid out by beneficiary designation? So what kind of liquidity do we have? Who has it? How are we going to pay for the mortgage? Because that continues to need to be paid. Right. We need to maintain insurance on the house. We need to pay car notes if there's equity there. We need to pay mortgage payments if there's equity there. So what we want to find out is, how are you paying those? Are you able to pay them? Is it already in foreclosure? Because sometimes that happens. How long can you keep it up? So very often, right? Yes, there's a bank account, but when we sit down with them, oh, that was paid to, my brother. Okay, great. Is he going to be able to help you pay those mortgage payments if the client can't? Sometimes the answer is yes. Sometimes the answer is no. But regardless of the answer, the mortgage payments have to be maintained, right? And
Pamela, I want to delve into this point because this is very real estate related, very, very relevant to things I deal with. I've had two interesting experiences recently, or interactions. Okay. One was I had been in conversation with a personal representative. She was waiting to get appointed. We were just, maintaining contact. Okay. Cause obviously she's not able to do anything yet, but just, and usually that's what I do is, I'm just, trying to be as helpful as I can, with where they're at in the process. Well, people share different things with you, what they're comfortable with. Right. And, I didn't know too much about the details, right? And she finally got to the very end and she called me up. She's like, Jeremy, I want to meet. Let's do this, right? Let's do it. Okay. So I'm like, okay. And I've got my checklist. I've got my things that I'm going to do before I meet the basic research I've got to do before I meet a potential client. And I always ask what I call the $1 million question. Okay. I go, okay, if you were on a game show and you had to guess correctly for $1 million, what you think a buyer would realistically pay for this house today, what do you think that would be? And I just want to know where their head's at. It's not going to change my opinion. I just want to know where their head's at. Okay, great. And how much is owed on the property? What kind of debt are we dealing with? Okay, great. So I get that. So I have kind of their expectation, and I have a sense of, okay, what's owed on this property. And of course, that's what they know. But usually the good thing about probate is usually it's already been discovered, right? They've already discovered, if there's any liens, judgments, or whatever, usually that's found. Not always. Sometimes something does come out of the woodwork, but usually we have a good handle of what's going on. That's not always the case with, let's say, more traditional sales, where I've been very surprised at the last moment that there's an IRS lien when the title company calls me. We won't get into that. So, so I'm looking at this, doing the research, and I'm just like, there's no equity here. And I'm like, and then I'm running these scenarios. Okay, what if I did it for less, just to help her, right? Just to help her. What would that look like? And even if I got paid zero, there's not enough there. There's still a potential to have to come to the table with money at closing. So I call her up and I'm like, look, I'm really sorry. I've really looked at. Obviously, I would love to sell the house, right? So if I could do it, I'd do it. But I'm like, I'm sorry. I've really looked at this a lot of different ways. There's just no way that you're going to be able to sell this with any profit at all. Even if I did it for free, you'd still have to bring money to closing. Now, here's the kicker in that. She had, as the personal representative, had put in money into the property. Okay. She had made several repairs that were expensive. She was putting money into the property, and she was maintaining it in terms of maintaining mortgage payments, the carrying costs of the property. And I told her, because she was devastated. I said, look, you can talk to another agent. I would encourage you, like, don't take my word for it. Just, talk to a few other people just so that you feel comfortable. But I mean, I already knew what the answer was. They're not going to say anything different. And that was really devastating. And that just shows you the danger of, and that's why I actually like to, when I'm talking with personal representatives early on, I like to really get a sense of kind of where they are in position to the property in terms of like, what's this carrying cost? How much equity is there? Because, and I just had an email the other day from another person, and they're like, should I pay the mortgage? Well, of course, I always tell them, talk to your attorney, I'm not here to give you legal advice, but I can't talk to them as a real estate broker. I mean, I can give them some general sense of guidance. And I was like, well, maybe. It depends, right? It depends, because how much equity is here? How much is owed on the property? Also, are you sure you're going to be appointed? You may not be appointed. It may not go the way you think it is. And so, you need to check with your attorney to see whether, in terms of you personally, what is your risk? What is your exposure? Right. And what I have found, Pamela, is that, a lot of people do not think it through. Right. So exactly this point here, they're not thinking through, like, okay, Is there enough equity in the house? Okay. Does it make sense for me to do whatever? So yeah,
Yeah.
I'm kind of curious if you could talk to that a little bit.
Yeah, actually, I had an interesting meeting with a potential client exactly on this point. This is maybe 2 or 3 months ago.
Hmm.
And she came to me. Her mom, it was recently passed away. Her and her much younger siblings were kind of at odds. And she kept telling me, well, my mom really would want me to take care of the property, fix it up. She always wanted to fix it up and sell it. And essentially, so right, it was very emotionally driven. And she felt like she was doing it for her mom. And I said to her 30 times. Finally, I ended with, I would make money to tell you to do it. And I'm telling you, do not do this. You are going to lose money on this. It just wasn't enough equity, certainly not to fix it up the way where they were talking about. And then there were some other personal issues to her that kind of, when I found those out, I was like, okay, we're not doing anything.
Yeah.
I'm sure you can get an attorney to do it, and I'm not doing this because it just doesn't make sense, and
Yeah.
it will be difficult to get done. So, I think, right, this is why on certain issues, I don't act as my own attorney, right? I have attorneys because you can't take the emotion out. And
Yeah.
so one of the things that your attorney, your broker should be doing is, talking to you about, okay, what makes sense? Let's look at the numbers. And so, yeah, ultimately she didn't end up doing anything, which is great. I mean, she didn't need to, should not.
Yeah, yeah, yeah. It's hard. It's hard, and that's exactly right. It's especially with the real estate because it is typically the largest asset in the estate. I mean, obviously there are high net worth individuals that have a lot of things, but the average person out there, the house is where most of that wealth is. That's what needs to be liquidated in the estate. That's really going to move the needle for everyone. And it's
Hmm.
important to really think about that. It really comes down to a business decision at the end of the day. Maybe they live there, they grew up there, mom was there. It's hard, but it is at the end of the day, especially when there's other heirs involved and they're kind of waiting. We gotta look at this a little bit objectively. And I would say as an attorney, real estate broker, you have to have a little bedside manner, right? You have to have a little bedside manner with these people and to try to understand the pain, the loss, but also try to get them to see the light, right? I want to go back to our scenario here real quick. So we're talking about the real estate. We're doing some analysis, right? So you're doing some analysis with them on some of these, the accounting, if you will, of the estate,
Hmm.
the assets, the liabilities. What are some other things that we're looking at, when I'm coming for a consultation?
Sure. So, debts are a big consideration, and sometimes people know them intimately, and sometimes they don't know much of anything. One of the first things, especially with a house that, was owned by an older individual, is did they ever receive Medicaid? The house is an exempt asset while that person was living, but assuming there's no other exemption after they pass away, right? No surviving spouse, some other things that I won't get into the details, but most of the time don't apply. Now the Medicaid estate reimbursement program can and has to pursue a claim against the estate if the house is passing through probate. And so, one of the things that you should discuss with your attorney initially is there a Medicaid lien? Right. We want to find that out, just like a mortgage. We want to find that out in the beginning so we know what we're dealing with. I have seen liens from, $15,000 to $500,000.
So let's dive into the Medicaid thing. Because I know that's one of the things we really wanted to cover in our time together. And I think it's a really good, I'll tell you something very interesting about this topic. I actually, when I was a new agent, I call myself when I was a baby agent. I did not know, like, before going in, getting into real estate, I taught all over the world. I was an English teacher. I taught, in several countries overseas. And then I came back to the United States and I got my real estate license and I started, selling houses. And I didn't know what really Medicaid was, to be honest with you. And one time
Mhm.
I had a problem where this person had this Medicaid issue, and it was like we may not have been able to sell the house because of the Medicaid problem. So I think a lot of people, believe it or not, do not know really about this issue. They don't really know, and it comes
Yeah.
as a surprise. At least from in my experience, it comes as a surprise to people. If I may, I just want to kind of break it down very simply for people, because we're kind of at a very high level, and we're looking at this with a lot of kind of context. But let's really break it down. Let's just start with, what is it? What is
Uh,
Medicaid? How is this a thing?
so most of the time when we get involved, it is okay, mom or dad or both need some sort of long-term care assistance, right? They can't take
Mhm.
care of themselves at home anymore. And then the question is, well, how are they going to pay for the long-term care? Right? That can be very expensive, $6,000 to $12,000 a month. And so, while the mom and or dad is living, the house is an exempt asset, meaning as long as it's under about 750,000 in equity, they don't have to count the house. I'm not going to get into the other resources, but then Medicaid can help pay for a Medicaid facility, a Medicaid bed in a nursing home, right? So this is, a benefit that you pay for through your payroll taxes, just like, a lot of the other entitlement programs. And so this is just that assistance as you get older, assuming you can't pay for that for yourself. And there's different exemption rules for various assets. And a lot of people assume, well, I won't qualify for that Medicaid assistance, which is not necessarily true, right? One of the things that we do is go through a deep analysis on what assets do you have, what status are they in, right? Homestead or not, for real estate, that sort of thing. Do you qualify? But essentially, it is just how you pay for, a Medicaid facility for that nursing home care, which, a lot of people cannot self-pay. Or if they do, this is what's known as the Medicaid spend down. They would dwindle their assets very quickly, essentially, potentially leaving nothing for their heirs and beneficiaries. And that is not always necessary, right? But that's what people do most of the time. They don't realize there's another option. But it's how you pay. The succinct answer is that's how you pay for long-term care when you can't otherwise.
Okay. So when the person passes away and now we have the estate, how does that
hmm
play into the picture? How does that come into the picture?
So whatever assets, so this is right, it's a federal program, and the state can make their own rules around it, but there's kind of federal minimums. So the state of Texas had to put rules in place around their Medicaid estate recovery program. Essentially, that, and I'm going to be general, there's exceptions to this, but if there is, at least $10,000 in Medicaid debt or lien, right? That's how much, in terms of resources, the Medicaid program used to pay for mom or dad in the nursing home. Then they have to pursue a claim in the estate to recover that amount. And so when I referenced earlier the 15 to 500,000 Medicaid lien, that means that person utilized that amount of Medicaid resources during their life. And now the Medicaid estate recovery program is looking to get repaid.
Got it. So the government's going to get paid. And so what are you seeing? What are the issues you're seeing around that, just generally, just in real life, the real lived experiences of the clients that you're dealing with?
Sometimes it's just a complete surprise, right? So we sit down with them in your scenario. Okay, what kind of mortgage is on the house? And let's understand that. And then we will get them to fill out MERP, Medicaid Estate Recovery Program, a claim form. We send it in normally in a few days. They'll send it back and say, this is the lien, or there is no lien. But we just need to understand, is it 500,000? Or is there no lien, or it's, or maybe we qualify for some sort of hardship exemption, that sort of thing. I won't get into some of that. There are exceptions to these kind of general rules, but just understanding, okay, the house is worth 300,000, the mortgage is 50,000, and there's a $25,000 MERP lien. Okay,
Mhm.
There's some equity in the house. And so we know we have some room to work with. It might still make sense. It probably will with those numbers. Make sense to, go ahead and move forward with the probate. But what we don't want to do is the scenario that you lined out initially and get surprised later. Yeah.
Yeah.
So,
Yeah.
I normally defer to well, not normally, I always defer to a real estate professional in terms of, should I put money in the house? That is not my thing. Is it a good idea to do right now? No. Should you talk to a real estate professional to understand what you might want to do later? Sure. But don't do that right now until you get appointed. But right, you're just wanting to understand. And so what I've seen, people will be unaware, and so they have the asset going through, quote, through probate, right? Maybe they haven't done any planning, so there is no will, and they've read that I can use an affidavit of heirship to transfer. We find out there's a Medicaid lien. And so depending on other facts, we may or may not be able to use an affidavit of heirship. And we might have to do a full probate with no will, right? Which is the whole determination of heirship and very heavy court procedure, depending on the circumstances. Or they've used a ladybird or transfer on death deed to pass the house outside of probate, which, okay, you have avoided probate. If there's a Medicaid issue, yay, we've avoided that, because in Texas, they can't go after other assets. We're what's known as a limited estate recovery, right? So Medicaid can only go after, the MERP program can only go after assets passing through the estate. Right. Okay. Something passes by beneficiary designation, transfer on death deed, ladybird deed.
By the way, that's kind of interesting. I don't think a lot of people, I think this actually highlights the value of estate planning right here, right? So this is exactly that. That's a very, I don't want to call it a loophole. It kind of sounds like almost kind of like a loophole, if you will, or a way around, this issue. But that's a very technical point that you would not know unless you're talking to someone like yourself, right?
Yep. And we use this to do very good planning because, and I've said this recently, I don't know how many times, people always want to avoid probate, but in this case, it's really the avoiding the MERP issue that can be, the deciding factor that, yes, this is a good plan. And a lot of these plans, unless we're talking about the Medicaid Asset Protection Trust, which sometimes is a good option, sometimes it's not, the kind of, quote, basic Medicaid planning on the estate planning side is really fairly straightforward. Sometimes I talk about these harsh things that can happen. Like, it's so easy to avoid them, right? We do this all the time. And, so instead of potentially losing all of the equity for the beneficiary's heirs, which is, I'm sure, not what mom or dad wanted. It's, this asset that they've worked for their whole life. They paid for it for their whole life. And people think is, they're either going to be able to reside there or, sell it and, recoup, sometimes what they've spent on mom or dad, to help them in their older age. But at any rate, then it gets, eaten up. So, but it's very easy to avoid.
In your practice, your clients, just if you could give it just like a percentage, like how many people are walking through your door where this is a major issue? This is something that kind of breaks what they were expecting was going to happen.
On the Medicaid side?
Yeah.
Probably 15, 20%. I
Okay,
mean, large enough.
Significant. Yeah. I mean, that's significant. Okay. Yeah, it is a thing. So this is something that definitely, when you're going through your estate planning, you're definitely going through this as a major issue to consider.
Oh, for sure. Yeah. And certainly, because you can still do the planning, even if someone's already receiving Medicaid, depending on what it is, So, something that we very commonly do is, and I don't know if we're gonna have time to talk about it now, but co-ownership of property, that's a lovely scenario in
Let's get
probate.
Right into it. We can move into that. Yeah, tell me, what do you think?
So one of the issues on the Medicaid side is people will do kind of DIY plans, right? We did the transfer on death deed, we did the ladybird deed. Now,
I have to
mom.
Stop you. I got to stop you for 1 second. Forgive me. I got to stop you for 1 second. I love, attorneys and real estate brokers have something in common. Okay. We have some things in common in because we deal with the public. Okay. We're dealing with the public, and there's a lot of different ways of understanding the world. Okay. And, when you said DIY, I already knew where you were going, and immediately I start to chuckle. Okay. I start to chuckle. Because it's right. People go now. Okay. This is America, right? This is America. All right. You're a citizen here. Okay. You can represent yourself. Okay. Right. You can represent yourself in court. Probably not a good idea. Probably not a good idea.
Oh.
And the more stakes are involved, the more, the less of a good idea it is. And, and then, and in real estate, it's very similar also. Yes, you can sell your house yourself. And, and you know what, for some people, if you're a sophisticated seller or, homeowner, maybe you can do it. I mean, it's not magical, right? It's like, if you understand how it works and you, not just the marketing part, but the contracts and all the things that are involved with it, the due diligence, etc. Okay. Yeah, go for it. But, the vast majority of the public has no business doing it. Okay. Has no
Yeah.
business doing it. It's a mistake. They get less money. They expose themselves to liability that would not be there had they been using a professional. And it's funny because I just got an email this morning from someone who was in an executor, and he wanted to sell the house on his own, right? So he's failing. So he reached out. Oh, that's good. I want him to reach out to me. I want him to reach.
Yeah.
I always tell them when they want to go that route, I always say I'm very compassionate. I always say, hey, I wish you all the best. God bless you. If it doesn't work out, I'm always here for you. And then he's circled back, and I don't want to say too much on this, but I just want to say that just as soon as you said DIY, I was like, okay, I know, because Pamela, it's a mentality. It's a way of
Absolutely.
thinking. Sometimes it's financially related. Sometimes I'm just trying to just really, save as much money as possible, even though doing it that way can actually cost you way more money in the long run, undoing things or whatever. They just have to, it's like beneath them, or they can't ask for help, or, and I've had some conversations about, we might be able to talk about this later, is in the age of AI, this has become even more interesting because people query these chatbots, and it's like, I've had situations where I'm at listing appointments and we're going over everything, and I'm literally in the appointment, and they're asking ChatGPT as I'm there, and then they're spitting, and I'm basically having this dialogue with ChatGPT basically across the table.
Yeah.
And a lot of times I'm just like, yeah, that's interesting, but that doesn't apply to you, or this is not really a concern for us, or right. So it's like, because it's like your context is so big, right? So this little chatbot does not understand all of the little things that are affecting your situation, right? So anyway, I'm going to be done with that. Let me go back to you.
So on the AI, because that's something that you said made me think of AI. So we recently had clients upload our documents, right? Presumably they came to us for privacy concerns, and they uploaded their documents into AI. Okay. So, this is now out there, right? But it was like 8 bullet points that AI went through and said, oh, these things are wrong. And I went through any concern I had that AI was going to decrease business to us was gone because they got it so incredibly wrong that if these clients had actually done what they said, it would have potentially cost them hundreds of thousands of dollars in taxes. And I mean, not to mention the other issues, but so yes. And we've had clients be in the appointment and asking, ChatGPT about various things in the plan, and they don't understand the nuance, or they just, in that case, they just got the code outright wrong. But yeah, it's so interesting.
It is because this is where professional knowledge, it's distinct from like for example with the law, you go to school, you're learning legal reasoning, you're learning procedures, you're learning all these things, right? But when you start contacting the cases, right, it's like, okay, it's like that's when you're seeing it actually happen in real life, and there's no substitute for that. There's no substitute for and the longer you're in the business, right, the longer you're practicing, you start seeing all the little permutations of things happening. I see that in real estate. If things happen, I'm like, things that I maybe I remember from the test, the real estate license test, and I thought, that will never matter. And then all of a sudden this thing comes up, like, oh, I remember that. Yeah. That's an issue that actually does exist in the real world.
I love it. Yeah. I love it when that happens in the office. We'll say, oh, this is a law school exam. Listen to this. Okay.
Yeah.
But and that's what makes things, it's interesting for us. I feel bad for the client going through it
Sure,
often
sure.
because it's not a great situation typically when you encounter those. But so DIY. So people will often hear, well, I can avoid the Medicaid issue if we have a transfer on death deed or a ladybird deed, and they'll DIY, and maybe there are 3 to 5 beneficiaries that now co-own this piece of real estate. And I'm sure you've seen this. There's 3 to 5, typically it's siblings, right, that now co-own this property. They often don't see eye to eye with what to do with that property. And so, right. And we see this when there's a Medicaid issue. Great. You've avoided the Medicaid issue, but we also see this when there is a probate, just a regular probate, no Medicaid issue. And we now have 3 to 5 owners, all with equal right to occupy. If they want to sell it, they all have to agree. And so very often we'll see one of 2 scenarios, sometimes both. One of the children of, mom or dad that passed away is residing in the house. And so we've had to file evictions to get one of them out. Or they now co-own. There's nobody paying the property taxes, even if it's paid off. Even the person, I can think of this one instance, even the person, they ended up not being able to hire because nobody could afford it. But there was about $400,000 in equity in this house. One of the heirs refused to move out so that they could sell it. And the county ended up foreclosing. Well, what was the option? The potential client that came to us wanted to partition, right, force a sale of the real estate. And, that is, everybody wants to avoid probate. You want to avoid a partition, right? Probate is easy. And in some instances, probate can be the answer to being able to get that done easier. And so I can think of another estate. I think the house was worth about $1 million, and we had to go through probate. There was no Medicaid issue. We had to go through probate. One of the beneficiaries was residing in the house, but there was no other asset, and there were some bills to be paid. And so we could sell the house. So no issue. Eventually we got the heir to agree, or the beneficiary to agree to move out. But if that had gone outside of probate and then were all co-owners, we would have had to partition. That would have been a much more expensive.
Tell me a little bit about partitioning. To tell us a little bit about that. What is it? Why do we do it? Why are you kind of negative about it?
It's just a much more expensive procedure, much more timely and costly. Timely in terms of calendar time. It just takes a lot longer to get done. And it's essentially, right, Texas law says if you co-own property, you all have the right to occupy it. It's an undivided interest. But essentially, Texas law says we can't force someone to co-own property. So any one of the owners can petition the court to say, I don't want to own this property anymore. They're not agreeing to sell. I want you, court, to force a sale of the property or division, right? But if we're talking about in town, which is what we primarily deal with, it would be a forced sale because it can't be equally divided. And the court will issue an order saying, done, it will be sold. There's the public policy, the courts are not going to force co-ownership of property. Oftentimes you have issues with, well, who's paying, for all the various expenses and keeping up the property and whatnot. So, you don't want a situation where you're now forcing people to co-own property, right? And this is where good planning comes in. What's the property? How do you want it divided? We're working with several clients right now on surveying out rural property so that it's particularly and specifically divided out to certain beneficiaries, and there's all kinds of options to do it. And it's highly dependent on what kind of property you have. But going back to the scenario that, we started with, the house, if there is a personal representative and there's a state debt, well, then we're not going to deal with that issue because they'll have the ability to sell it. Either through a will with good powers, through a will with consent by the beneficiaries, no will with consent by the heirs, or just getting the court to approve a sale. But a sale through probate is much easier than a separate partition action.
Typically, how does that look, like the partition, how does that look in practice? What's the judge thinking when he's going through this? Like, I mean, what's the
Well,
thought process?
yeah, essentially, I mean, the law just says you can't force someone to be owners. So they're
Okay.
going to order the partition.
Okay.
And then you just have to bring evidence about, why, what kind of expenses various, heirs or co-owners have, and then value of the property, right? What
Hmm.
is the market value? Are we appointing, people, and what kind of expert testimony, right? So they're just going to take all that into account and make sure that everything is equal. Now, what ends up not being equal is who brought the partition action, who's paying for that.
Sounds like a lot of billable hours. Yeah. Wow. Okay. That's very interesting. I've come across a few prospects who have talked about partitioning, like they're having problems, and of course that's way beyond my pay grade of what I can discuss with them about. But I have heard it surface a few times, and
Hmm.
you mentioned something kind of interesting, and I've talked about this with other attorneys as well, which is when there's like co-executors,
Mm,
there's several people involved, and it's so interesting. I'm always a little bit when I go into those situations, I'm a little bit concerned because they almost never are fully. Sometimes they get along, but my experience has been typically it's not a good idea. I think it's a terrible idea because one of the great things about an executor or an administrator is that the buck stops with them, and sure they have liabilities for they got to do it right, but it's like they're the decider, and it's like maybe
hmm.
they will work in consultation with others that are involved, but if they can't, and I've had that quite frequently where it's like they're bringing people into the process, and so maybe we'll have a Zoom call with everyone, all the heirs involved, and I'm talking
Sure.
to all of them. Uh,
Yeah.
but sometimes, and they kind of, come up with a mutual kind of like consensus. But I've had some where it's like they can't figure it out, and they're just like, Jeremy, it's okay, don't worry, I'm in charge here. This is what we're gonna do, and we do it. And and typically, I think that's the best. The time where I've
Absolutely.
experienced co-executors, or it's just like they usually are just on different planets. They have different ideas of what's going on. It's much harder to get it done. It usually costs them money. Like I've had situations where they can't decide on an offer. Like we've got 3, 4 offers. It's like they can't figure it out. I'm telling them
Mm,
what I think. They should probably do what I think, but
yeah.
but they can't. They can't because it's like they've got like childhood trauma from when they were kids, and they're still fighting
Or
out. They're still
spouses are
fighting about it.
involved.
Yeah,
Yeah.
yeah, yeah,
Yeah.
yeah, yeah. What do
Yeah.
you think about that? What's
No,
your
I
thought on that?
completely agree. On the planning side, if clients want to name co anything, and there are specific circumstances where we will recommend co, but not giving each the power to act individually, right? Never requiring them to all join because of the issues that you just talked about. So, and to the point where if they, despite our recommendation, decide to do that, we're putting a memo to the file. We recommended not to do this because it often will cost them more money. So on the, probate, trusted administration side, if anything comes to us and they want to hire us to represent them, part of the conversation, and they'll sign a multi-party representation clause in the engagement agreement, is we represent both of you and there's a potential for a conflict. So if an actual conflict were to
Mm.
arise, y'all would each seek your own separate legal counsel. And so that's what we talk about planning clients is, well, most of the time it doesn't solve issues, it creates them. And you could really be increasing your attorney's fees, right? If both of them then have to seek their own separate legal counsel. This particular client that lived in California, this was years ago, fighting with siblings comes to mind, where I think they were co-executors. Yes, childhood trauma that still, you know, is around today. Always, we see that probably weekly, in the office. And sometimes it's a big issue, sometimes it's not. But in that case, not only does it double because they each need their own legal counsel, it more than doubles because now, and maybe it would have done that anyway, but the co-executor issue can triple or more expenses in terms of the attorney's fees. But yeah, always, one of the benefits is that you're naming one person to take care of things, right?
Absolutely.
And pick, people normally when we sit down to do the planning side, there's one child or and sometimes, right, it doesn't make sense to name the child. If there's a lot of drama, I can think of this other client, and they never hired, and I feel really bad for their daughter because we know that her brother is going to sue her.
Oh,
That is his stated goal, and the
oh,
parents are refusing to name a professional to serve. And in that case,
that's
absolutely,
so sad.
like, name the professional. The professional trustees, executors, they deal with that day in, day out. This is their thing, and you will. Of course, they're going to earn a fee, and that will be less than whatever you're going to pay to defend that lawsuit.
Absolutely. Can you tell me a little bit? This is actually new ground for us on the program. So I want to take advantage of this. Tell me a little bit about the professional trustees.
Mm,
I haven't had one attorney on this podcast talk
really?
about it. Yeah, so I'd love for you to share a little bit about that.
I mean, I think it makes sense, right? And so these are trust companies. There are attorneys that will do this, but what we will typically recommend is, a professional trust company, right? So there's Austin Trust Company here in town. There's RBFCU, Cumberland. I'm going to leave one off and they're going to be upset. Charles Schwab, there's other smaller ones. They're set up in different states to take advantage of some of the other, state trust laws, depending on what you're doing or what kind of assets is in the estate or the trust. One might make sense more so than others, right? Typically, the only way I'm going to recommend a Schwab is if there's only liquid assets, no real estate, right? If there's heavy real estate in town, I might recommend an Austin Trust Company. But there's all kinds of options. And, the fee structure is typically an assets under management structure, so it's a percentage of whatever they're taking care of, and it only lasts however long the estate lasts, or if it's a trust, however long the trust lasts. So say, for example, we have a couple that's doing planning and, I don't know, they're worth 5 to 8 million. That's a pretty typical client for us. And, the clients will, depending on what kind of trust, but in that case, we're probably doing, let's just say it's a revocable living trust. They're going to be the trustees, the clients are initially. And it's only when both clients passed or one has lost capacity that professional trustee steps in. And
Okay.
so depending on what kind of subtrusts we're creating or, what's involved, it could be a really short period of time or it could be many years, So, it needs to be tailored to, asset level, what their particular goals are. But they'd step in and, they'll just do what needs to be done. And again, it's, kind of like using us to take some of the emotion out, the heaviness of the emotion. They're going to serve the same role where they're just going to look at the trust agreement or the will and abide by it and do, it in accordance with the law, as opposed to, doing what they feel like. It may be
Yeah.
ignoring the will or trust often, and they do this all the time. So yes, there are fees, but when we represent them, they don't have to ask us a lot of questions along the way because they do it. So you will have
Right.
a decrease in attorney's fees as well.
Yeah. Yeah.
So, it's definitely something that you want to consider. Even some clients, do it where everybody gets along, but one, there's always the chance that they won't. And, money changes things.
It does. It does. It frequently does.
And, two, some clients will do it just for ease. Well, no, I don't want to burden my children because it's a process. Whatever you put together, there's some sort of administration that will have to happen. And whether it's court or not, you need to do certain things. Even kids that are, very well capable of doing it, it's still a process. And if they have, professional jobs, families of their own, it can take time. So some people do it just for that.
That's a very good point what you just said. And this is, I think, a key point is that people underestimate how much time it takes to do these things. And it's people have their own lives. This is one of the things I kind of say, even in my own marketing, is that it's like at the end of the day, you want closure to this situation, right? It's like we have this thing, it's open and you want closure, and you can get to that closure quickly or it can take a very long time to get
Yeah.
that closure. It may cost a little bit of money to get the efficiency, but usually that efficiency is going to be well worth it, right? And so it's kind of goes back to that DIY kind of that's kind of the theme of this episode, I think.
Yeah.
The DIY kind of mentality. It's like, just if I'll share one quick story with you just on this point. I just wrapped up a sale not too long ago, and he was just a penny pincher. And he's a nice guy. He's a very nice guy. He actually was in St. Louis, and I did meet. He had to come down here at one point. I actually, a lot of my clients, I've actually never met them in person because a lot of them are at a distance. But he had come down from St. Louis, and the thing is that he even there. I don't know if you're familiar with these, but there's these companies. They're like kind of like lead generation companies for attorneys, and they have like their own platform. And then, but you have to communicate with the attorney through their platform or whatever, right? And it's like to try to do it very cheaply. And he had a situation where it was kind of complex. Like he had a complex situation. He was also starting to face foreclosure, on the house, and there's all these things going on. And his attorney finally said, like, look, I can't we can't communicate effectively through this platform. I have to talk to you on the phone. I gotta see you on Zoom or something. We gotta have more communication here. And same thing with real estate. He as I'm sure you're aware of, when properties when a filing happens in probate, because it's public, basically everyone starts descending on the personal representative, especially with the real estate. And the thing is that like in his case, the fact is, this is just fact. I'm not going to say 100%, but I'm going to say 99.99% of the time, there's no sale that you're going to do privately with one of these investors that is going to be better in its outcome, financially and otherwise, than it would be paying a real estate professional, having it on the open market, selling it to the open market, so that maybe that investor will buy it, but he's going to buy in competition with the entire market.
Right.
There's probably no situation where that's going to where going that other route is going to be a good idea. And but he's like he thought he could hustle the investors. Well, the investors, they're professionals. You're just one of 1,000 people they're talking to. They're doing this every day. And he got frustrated, and then he came back. He's like, Jeremy, he's like, I tried. I can't deal with these people, because it's like you're coming at it from the perspective of you're not a real estate person. You sold a house 7 years ago. These guys are doing it every single day. I'm doing it every single day. So it's like you're not gonna you're going to a gunfight without a gun. And it's similar, I think, with legal, right? It's like it doesn't make sense. And I think that goes back. If I could just end kind of start concluding our time here together, is I think that's a good segue into the need to really get your things in order. So, right. So, a lot of times, hopefully a lot of the executors and administrators that don't have their stuff in order, hopefully they get inspired to actually do their estate planning. But I think that's why it's so important. And so tell me, how can people get in touch with you? So, a lot of, there's going to be people watching this, there's people listening to it. Hopefully they'll stumble across it. Probably they might even type in your name, and then they'll come up with this episode. They're going to see what you're saying here. Tell me, where can people find you? How to get in touch? What are some things that people, can come to you with to kind of get that process going, to talk about how to resolve some of these things in advance before they have to deal with it in this probate situation?
Yeah. I mean, like I said, about half of all the work we do is on the estate planning side, right? Understanding your scenario and what issues might arise, because we can see it very quickly.
Yeah.
With the assets and just the relationships and how you want to pass things along. What's the best way to do that and avoid some of those landmines? So, of course, we have, the website, www.haileypettylaw.com, no hyphen. We regularly run webinars on various topics. Will versus trust. That's a very common question that we get from clients. What is trust funding? What is probate? Where I kind of go over. There's various probate options, depending on, assets, debts, that sort of thing. And so probably, starting with those. Oh, my favorite that we run about once a month is, you think you automatically inherit your house when your spouse passes, not in Texas.
That's a
It's
big
not
one. That's a
automatic,
big one.
right?
Yes.
So, I would encourage them to look at all of those because I go over, the big questions that people come with. And so at least you have some idea of, how the process works, what we're talking about, so that, you can start to have an idea of who do I want to serve? Where do I want my assets to go? These are who do I trust in my world to take care of things while I'm alive, after I pass away? Am I concerned about long-term care planning, or do I just want all my assets spent down? We get all kinds of answers, but really having a good idea of what it is you want, because, we will help provide that architecture for how to make it happen. But yeah, I would encourage them to watch those things. I believe they are all on the website. I have a separate videos section. If not, you can reach out to info@haileypettylaw.com to get links for those. And so really start there. And then we do a free consultation, so you can get an idea of our process. I talk about it somewhat in the webinars, but our process, and, you can get better flavor for us.
What do you think is a defining characteristic of your practice and your firm? What do you view as like really maybe sets you apart, or just your approach, like your angle to it?
Mm-hmm. So really understanding the client's goals and not giving them a cookie cutter. Well, here's estate planning. And, this is what everybody should do. Well, no, I mean, assets affect that. And then goals. Even people with the same assets might have completely different goals. And so we're going to recommend something different. And so, really understanding what the client is trying to accomplish, and then us providing that. And then if we do trust creation, right, we're going to advise as part of our process on trust funding. I can think of, this was maybe 5-6 months ago now, meeting with a client in San Antonio, and she thought, right, her husband had died. She wanted me to look at the trust, and I looked at it and I said, well, your house was never put in the trust. And so now you haven't probated the will. You co-own your house with your stepdaughter. We need to probate it within the next year and a half. So, what could have avoided that was she created the trust, but she never transferred the real estate, right? Just transferring the real estate, right? We do that on every estate or on every trust plan. And so, but more than that, right? Oftentimes you'll see the real estate transferred in, but no other liquid assets transferred in. And arguably that's one of the most important things about trust planning, is to give them liquidity. And so, walking them through the trust funding process after everything's signed, having a trust funding call. Okay, did you transfer everything in? If not, what are any roadblocks? So really walking them through, and that's on every trust plan, right? It's not, an additional thing. We do it on every one because it's so important, right? I would rather you not create a trust if you're not going to fund it, because that's one of the other scenarios that we don't love on the probate side. We have a trust, nothing's in it, so it doesn't, not only does it not accomplish anything, but it makes it more difficult, because now,
Right.
I can think of this probate matter. I think we're concluding it now, but probated both parents' estates and then had to do trust administration.
Oh.
So, and there was nothing in the trust. So it didn't accomplish anything, only to make it more difficult.
Wow.
So, that was a DIY plan.
Wow.
So, so the trust funding piece, and then really kind of on the education piece, providing clients the drafts, having a call to review the drafts, so that we know, okay, this is how this works, right? This is what this says, making sure it's what the client wants. And so they understand how the plan will work later, and confirm, okay, this is accurate. This is what you want. Great. And then, of course, facilitating the signing. And most attorneys do that, but not all. The signing can be just as important. right? It can fail if things aren't signed correctly, even if the plan is well drafted, So, several points, right? Really understanding the
And
client goals, trust funding, making sure it fits.
do you deal with contested and uncontested and contested
Mhm.
estates, or what? I had one attorney that I was talking to on the program, and he said, "I'm a lover. I'm not a fighter. I don't like I don't like going to court." How are you? Are you a lover and fighter? How are you?
I mean, I don't love doing them. We will take them to mediation, and beyond mediation, we will hand it off to a litigator. But we will bring on a co-counsel, a litigator, fiduciary
Okay.
litigator that we work with to assist in that if the client wants us to stay on. It's really, determined by what the client wants. Sometimes they want a clean handoff to a pure litigator. Sometimes it makes sense. I have a call at 3:30 today on an estate that's in litigation with co-counsel and the client. And, but a good rule of thumb is we'll take it through mediation after that. If it still hasn't settled, we're not going to take anything to trial.
Got it. I want to thank you, Pamela, for being on this podcast. Thank you
Yeah.
for sharing your insights and your experience. It's so valuable. I'm sure that when people stumble upon this podcast, the video or the audio, they're going to take something of value. And I really want to thank you for taking your time. That's, for attorneys, that's probably your most valuable thing is your time. So I really want to thank you for that. And we're definitely going to put all of your information in our show notes so that people can contact you if they want to get in touch with you. And again, I just want to thank you so much for being on the program.
Yeah. Thanks, Jeremy. It was enjoyable.
Awesome. Well, that concludes this episode of the Texas Probate Real Estate Podcast. My name is Jeremy Kritt, owner and broker of Kritt Real Estate, founder of Texas Probate Real Estate. If you are an executor, administrator, or personal representative that has real estate in probate and you're thinking about selling, get in touch. I look forward to talking with you and seeing how I can help you. See you on the next one.